Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video, I'd like to talk a bit about fraud and what that means to you if you want to come in the United States or if you want to adjust status or get a visa, what that means. Now, there's one type of fraud where the Eighth Circuit Court of Appeals just ruled that essentially somebody was ineligible to adjust status because they put that they were a U.S. citizen on an I-9 application. The I-9 is what you use to apply for a job, and it proves you have verification and legalization to work. And by putting and checking the little box that they were a U.S. citizen, allowing them to work, this person was denied the ability to adjust status. So, you know, that person's inadmissible. So then the question becomes whether a waiver is available. And for all intents purposes, if one declares one is a U.S. citizen, and this is after 1996, then they are not eligible for a waiver of inadmissibility, at least for the green card. They can apply for a non-immigrant waiver, as that is not a bar to a non-immigrant waiver, assuming you have a non-immigrant visa. Now, the issue also is, what about the fraud? Where does, you know, claiming to be a U.S. citizen, or where does the issue come up? So essentially, when you look at the U.S. immigration policy here, it essentially says that, you know, especially in claiming to be a U.S. citizen or a fraud related to that area, that you must be trying to gain some benefit from the United States, you know, from U.S. immigration. And believe me, it can be very tenuous. It can, you know, they can stretch what you did and make it look like you had tried to obtain you know, some benefit from U.S. immigration. But let's say that you're, you know, from a different country and you committed some kind of welfare fraud or some kind of governmental fraud there, which allowed you to get more money or more benefits or more housing or whatever it is over there. Well, that may be fraud, but that's not going to be trying to obtain any benefits from the United States. So you wouldn't be inadmissible based on the fraud statute as far as that goes. You might be inadmissible based on committing a crime involving moral turpitude, at which point you'd have to analyze it on that ground, of which I have other videos on there. So bottom line, two things. One, do not put you're a citizen on any U.S. application anywhere, because they're going to claim it has to do with benefits. If you put you're a U.S. citizen on any application in the United States, it's to obtain a job. Why else would you do it? And to obtain a job is to obtain an immigration benefit, because if you're not a U.S. citizen, you're not just magically entitled to work. Of course, a lawful permanent resident is, but you know, they can easily say that it's obtain a U.S. benefit. Secondly, if you have committed this type of fraud outside the United States and it has nothing to do with the U.S. government in any way whatsoever, then you're not inadmissible based on that particular crime as far as the fraud goes, but you might be inadmissible based on crime of moral turpitude, depending on the sentence and other factors. Okay, if you like the video, click like, subscribe, and we'll have more videos in the coming weeks. And also, feel free to send me an email if you'd like to see a video on some subject I haven't done. Granted, I've done 725 videos, give or take, but there's always somebody somewhere that has a question and would like to have a video on a particular subject. So just let me know. I'll put one out there. Okay, more in the coming videos.